Hello everyone. Today we'll be going to speak about one of the most significant constitutional developments in recent times. State of Tamil Nadu versus Governor of Tamil Nadu and the larger constitutional questions examined through a presidential reference and under Article 143. This issue is not just about Tamil Nadu, it is about the role of governor, the meaning of Article 200, the scope of Article 143 and ultimately the balance between democracy and constitutional authority. At the heart of this controversy lies a simple but powerful question. Can a governor indefinitely delay a bill passed by an elected legislature? The conflict began when the Tamil Nadu Legislative Assembly passed several bills. These included amendments removing the governor as chancellor of state universities, administrative reforms, structural changes in governance. These bills were sent to the governor for assent under Article 200 of the Constitution. Now, Article 200 gives the governor four options: give assent, withhold assent, return the bill for reconsideration, reserve it for the president. However, the governor did not act promptly. He delayed several bills for months. Some were returned after long delays, some were kept pending, some were withheld even after reconsideration. The state government approached the Supreme Court of India, arguing that the governor cannot frustrate the democratic will of the legislature by inaction, because similar tensions were arising in other states too. The matter assumed national importance. Under Article 143, the President of India may refer a question of law or constitutional importance to the Supreme Court for its advisory opinion. It is important to understand it is not a regular adversarial case. It is consultative. The opinion is advisory, but carries enormous constitutional weight. So when constitutional friction between states and governors became a recurring phenomenon, the broader legal questions were examined in this advisory framework. Let us understand the main issues. Is the governor bound by aid and advice? Article 163 says the governor shall act on the aid and advice of the Council of Ministers except in matters where discretion is expressly provided. The key question was, is Article 200 a discretionary power? Or is the governor largely bound by the elected government? The Supreme Court reaffirmed earlier principles laid down in Samsher Singh versus State of Punjab, Nabam Rabia versus Deputy Speaker. The court reiterated that the governor is a constitutional head. Real executive power lies with the elected Council of Ministers. Discretion is the exception, not the rule. Can the governor indefinitely delay bills? This was the most important issue. Article 200 does not specify any limit, but constitutional silence does not mean constitutional permission. The court emphasized the doctrine of reasonable time. In a parliamentary democracy, deliberate inaction can defeat legislative supremacy. A pocket veto cannot exist in a state framework. The governor cannot simply sit on bills indefinitely. But what happens if the bill is repassed? Under Article 200, if the governor returns a bill and the legislature repasses it with or without amendments, the constitutional expectations is that assent must follow. The governor cannot repeatedly block the same bill. Otherwise, it would amount to undermining representative democracy, converting a nominal head into a political gatekeeper. This case is not just technical, it is philosophical. It touches upon federalism, constitutional morality, democratic legitimacy. The court highlighted India follows cooperative federalism, not competitive obstructionism. The governor is appointed by the union, but functions within the state constitutional structure. If governor acts as political actors rather than neutral constitutional heads, the federal balance collapses. The court stressed that the constitution must be interpreted in a manner that strengthens democratic institutions, not weakens them. This case clarifies that governors cannot exercise unchecked discretion. Constitutional silence cannot be misused. Democratic mandate cannot be stalled by procedural delay. Federalism is a basic feature of the Constitution. It also revives debate on whether Article 200 should include a time limit, whether reforms in governor appointment are needed, whether clearer constitutional guidelines are required. This matter affects Tamil Nadu, Kerala, Punjab, West Bengal, and potentially every state in India. It strengthens the principle that the elected legislature represents the will of the people. Constitutional functionaries must facilitate governance, not obstruct it. To conclude, State of Tamil Nadu versus Governor of Tamil Nadu is not merely a dispute about assent to bills. It is a constitutional movement. It reminds us that democracy is not just about elections. It is about respecting institutional rules. It is about acting within constitutional boundaries. It is about ensuring that power, even constitutional power, is never arbitrary. And ultimately, it reinforces a simple but powerful idea. In a parliamentary democracy, sovereignty rests with the people and their elected representatives, not with unelected constitutional heads. I really hope you liked the session. Do like and subscribe the channel now.